Imagine if an officer used deadly force during a simple traffic stop and the court said that the only thing that mattered was the split second when he pulled the trigger. Nothing else could be considered, and nothing that led up to the incident could be taken into consideration by the court. Now imagine that the Supreme Court, in a 9-0 unanimous decision, rejected that rule, only for the lower court to ignore exactly what the Supreme Court said. Well, that is what's happening currently in a critical case that is now likely heading back to the Supreme Court. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the notification bell and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. I also want to thank the sponsor of this video, which is Patriot Gold Group. If you've been watching the markets closely, you will know that something unusual is happening. Silver has surged to over 158% in 2025, and this move isn't over yet. It looks like the opening chapter is just happening right now. This is not the finale at all. Gold is up 60%, silver is up 150%, and that kind of move doesn't just happen by accident. Now, as a member of the Second Amendment community, this concept already makes sense to you. You believe in self-reliance, in not outsourcing your safety, and in being prepared before you're forced to actually react. Your finances deserve the same type of mindset that your self-defense also gets. That's why I work with Patriot Gold Group. They help Americans protect their savings with physical gold and silver, and these metals you can have delivered to you or held in a no-fee-for-life IRA. They specialize in rolling over IRAs and 401ks into real, tangible assets that you actually own. Now, this isn't about market panic or anything like that. It's about positioning yourself and putting yourself in the best position to defend your finances like you would defend your life. So if you're interested, check out Patriot Gold Group. You can mention Armed Scholar when you check out to get the best-in-class service from the Patriots that are focused on protecting your investments, or you can call 888-581-3830, and you can get also a free investment guide and see if you qualify for a no-fee-for-life IRA on qualifying rollovers. As I mentioned in the intro, in this video, we're going to be discussing a recent 9-0 unanimous decision issued by the Supreme Court. This case involves the Fourth Amendment's protections against unreasonable searches and seizures, and when law enforcement activities through excessive force impact those rights. This unanimous decision came in a case called Barnes versus Felix, and this case may already be heading back to the Supreme Court for re-review just 6 or 7 months after the Supreme Court issued that 9-0 ruling. That is because the Fifth Circuit has issued a new ruling in this case in light of what the Supreme Court said in that 9-0 ruling. The Fifth Circuit has once again ruled that the officer's actions are protected even under the totality of the circumstances approach, and the en banc panel in this case denied review to taking a look at that ruling. The Fifth Circuit has engaged in some very interesting reviews of this case even after the Supreme Court remanded it to them with that 9-0 decision, which actually teased this case up to potentially go back to the Supreme Court once again, just 5, 6, 7 months after the Supreme Court already ruled in this case. Now, the facts surrounding this case are as follows. There was a police officer who pulled over an individual, Ashton Barnes, for suspected toll violations. Those toll violations were picked up by a Houston area camera, and I believe that those toll violations were also connected to the rental car that Ashton Barnes was driving. Now, Felix pulled over Ashton Barnes, told him to exit the vehicle. Barnes opened the door and acted as if he was going to exit the car, but then with a horrible decision, decided to attempt to drive away. Now, reacting in a split second, the officer also made a horrible judgment call and decided to jump onto the ledge of the car as it was driving away. He then fired 2 shots at Ashton Barnes as the car was driving away with him on it, as he was holding onto the ledge. And really, this entire incident happened within 5 seconds. Ashton Barnes passed away at the scene, and in response to this incident, his mother decided to sue the police officer and alleged that the officer there violated Barnes' Fourth Amendment rights against excessive force. The district court on review granted summary judgment in favor of the police officer, applying the Fifth Circuit's moment of threat rule. Now, the Court of Appeals ultimately affirmed, so the Fifth Circuit affirmed this decision, explaining that the moment of threat rule requires asking only whether a police officer was in danger at the moment of the threat that resulted in his use of deadly force. Under that rule, events leading up to the shooting are not relevant and should not be considered. Like I mentioned, this case made its way all the way up to the United States Supreme Court, and on review, the Supreme Court issued a 9-0 unanimous decision in favor of the individual here, Ashton Barnes. They held in this case that a claim that a law enforcement officer used excessive force during a stop or arrest is analyzed under the Fourth Amendment, which requires that the force deployed be objectively reasonable from the perspective of a reasonable officer at the scene. The inquiry into the reasonableness of the officer requires analyzing the totality of the circumstances. That analysis demands careful attention to the facts and circumstances relating to the incident. So in this case, the Supreme Court rejected the more limited moment of threat analysis that was used by the Fifth Circuit, and instead they applied the totality of the circumstances approach. The Supreme Court stated that most notable here, the totality of the circumstances inquiry has no time limit. While the situation at the precise time of the shooting will often matter the most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. Prior events may show why a reasonable officer would perceive otherwise ambiguous conduct as threatening or instead as innocuous. And based on that, they ruled in favor of Ashton Barnes that the Fifth Circuit should have used the totality of the circumstances approach instead of the moment of threat rule. Now, once the Fifth Circuit got this case back, one of the interesting things that they decided to do is the panel in the Fifth Circuit decided to not hold oral arguments in this case or ask for additional briefs in light of what the Supreme Court just said in their ruling. Instead, the three-judge panel in the Fifth Circuit just re-ruled on this case on their own, again without any additional briefs or any new oral arguments. In the new ruling, the panel held that even under the totality of the circumstances approach, the officer's actions were warranted. The panel reasoned that any vehicle flight creates a deadly threat and that the police officer reasonably used lethal force to prevent a dangerous chase. Because of that and that very quick new decision without additional arguments or briefs, Barnes's attorneys then petitioned for the Fifth Circuit en banc panel to review that ruling. The petition argued that this new ruling by the panel contradicts the Supreme Court's ruling that they just issued. So really here, what the family is asking for is a correct, proper review of this case, at least for them to be able to potentially submit briefs and oral arguments based on what the Supreme Court said. The petition urged for a rehearing en banc in the Fifth Circuit, but also they pointed out that the new ruling by the three-judge panel creates this kind of per se rule where an officer may be able to shoot anyone simply because maybe they're fleeing, they're driving away, even if the initial stop, is not related to any criminal incident, or maybe there's no probable cause or any, serious incident involved with this. But the fact that, someone is simply driving away under this new ruling potentially opens the door for officers to use deadly force. The petition argues that this conflicts with Supreme Court cases and with long-standing Fifth Circuit precedent that fleeing in a vehicle does not automatically justify deadly force. However, the Fifth Circuit en banc panel on review of this decided to deny review to the case, and they sent a notice that the Fifth Circuit is denying review to this case en banc. So this is something that we will have to be watching closely to see how does this play out. It's surprising that the Fifth Circuit panel decided to issue a new decision on this case without requesting additional briefs and also without additional oral arguments in light of what the Supreme Court just said in this case in that new ruling. And even now the en banc panel has denied re-review of this case despite that lower court ruling. This now tees this case up to go back to the Supreme Court really soon after they just issued that ruling. After they issued that 9-0 unanimous ruling in this case, it remanded the case to be reevaluated and redecided based on what they just said. But the Fifth Circuit decided to, not do briefs or oral arguments or really take any of the parties' considerations or arguments in light of what the Supreme Court just said. They ruled on this case on their own. The Fifth Circuit en banc panel denied review to this case, and now this case is probably going to be heading back to the Supreme Court really soon after they just already reviewed this case. So that is what's happening now in a critical case, which was recently ruled on by the Supreme Court and may already be heading back to the Supreme Court for a new review. So as we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm or Al Gore's rhythm. It adds fuel to his jet and just tells the YouTube algorithm that you appreciate this type of content and it should share it with more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.